And thank you, Taxmann, for giving me for organizing this webinar on a contemporary topic, which is impacting not only the professionals, but our entire economy. And this is a burning topic. Many of us are feeling many problems. So thank you very much for allowing me to share my thoughts in one of my favorite topics, PMLA. And thank you, dear participants, my dear professional brothers and sisters, for taking out time to make this session as an interesting session, because I'm sure this session will be made as a participative session. In the end, we will take up some queries, etc., the issues which you might be facing, the apprehensions you might be facing. So with that thought in mind, let us begin our deliberations. So I will request the organizers to allow me to share my screen so that I can take up this share my screen on the PPTs. So whether my PPTs are legible now?
Yes, sir, this is
visible.
Perfectly visible.
All right, visible. Yes. So obligations of reporting entities under PMLA. Now, though I have named this as obligations, and everybody is viewing it as extra obligations, but I will begin my deliberations whether these are obligations only or this is something more also. You might be wondering what else it can be. So I would say these are not mere obligations. These may at times also be the means of empowerment. Now, you might be thinking that how it is so, because something which empowers you to know about someone gives you empowerment, and that too in a structured manner, that too in an authentic manner, that too in a responsible manner. So everything put together, it may be a gateway for further empowerment of we professional brothers and sisters. Having said so, and I know what I am saying. It is other side of the coin, which probably I am trying to put before you. As you know, that money laundering has been perceived as a global problem, global issue, global menace, global threat. Therefore, during past decades, the UNO, the United Nations, has placed a greater emphasis with the help of its member countries to bring out stringent laws to deal this menace. And that is why at United Nations General Assembly passed a resolution that all of its members in their respective jurisdiction would pass a suitable legislation to curb this menace. And that is how, in pursuance to that only, this resolution was passed in 1998. And that is how, after 4 or 5 years working, this Act, Prevention of Money Laundering Act, has been brought on the statute in our country also in 2002. And since then, in last 20 years, 2 decades, it has seen many developments. Many changes have been brought out time to time. And quite recently, since last few years, its need has been reinforced by the member countries of the United Nations again, especially after constitution of Financial Action Task Force. Now, Financial Action Task Force has certain recommendations on the basis of which every country is supposed to bring out suitable legislation and requisite amendments therein, so as to tackle this problem on a contemporaneous basis, meaning thereby when the criminals or the crime changes its color, changes its methodologies, tones up, makes it complex in a different fashion, so should be the defense mechanism of the country, the legislative framework of the country, to deal with all such situations. And in line of that direction only, you would be aware that nobody would like to be blacklisted by FATF, the kind of situation which a country like Pakistan is facing. Therefore, all maximum possible recommendations of FATF are being implemented. FATF recommendations have been adopted with regard to this maintenance of records, KYC norms, etc., by various countries already. And respective amendments in the law has been brought out, like countries like Canada, Australia, what more? UK's, US, and probably UK is also Europe, many countries in Europe also. We have in our slides brought out all those recommendations of FATF and how the countries have adopted it. And in November, upcoming November 2023, there is a visiting meeting planned by FATF in India also, wherein FATF will check India's position with regard to various compliances of the recommendations of FATF. So, the reason why these two circulars, especially for which we have gathered here to discuss, I perceive there are two reasons for which these have been brought out. First reason seems to be this only, that since FATF meeting is scheduled in November, so India has to demonstrate the will and the action on the part of Indian government to show compliance with the legislative recommendations of the FATF. That seems to be the first reason. Second reason is also something like that which required some kind of suitable action. As you know that, you must have read in the newspaper that various Chinese companies were formed in our country in a manner which was not properly genuine, not properly legal, and it has been perceived that by forming such kind of companies, there has taken place A, leakage of revenue, B, leakage of flux of foreign exchange out of the country. So tax leakage as well as outflow of foreign exchange not in a legal manner is something which has disturbed our government and has dented the economy. That is what has been felt in last couple of months. And that is why there arose an urgent requirement to bring out a law which could curb such kind of practices, that countries like China can incorporate companies here in India without responsibly coming up themselves, without bringing out themselves in the country, without adopting a suitable legal position here in India, without adopting a responsible role in our country, using Indian citizens' names and designations, and carrying out the business in a benami manner or a disguised manner, or in a manner which is not fully compliant with the laws of the country as far as substance is concerned, by nominating directors from India only, by creating a kind of facade here, by creating layers, etc. So all those things have been perceived to be denting the economy. And that is how it could be a reason, another reason, that is how these circulars have been brought out under PMLA, though the law already provided that the government can at any time bring out suitable amendment in rules or by way of notifications to bring out requisite activities within the area where the obligations are required to be fulfilled by the reporting entities. Third reason, of course, could be that within our country also, there may be some companies which are created and run in a dubious manner, where the real persons behind the company are not known, suspicious transactions are done, and nobody is held responsible for that because of the way the layering and structuring of those companies have been done, the way the masking has been done with regard to the company and the transactions being done by the company. So it appears to me there could be this 3-4 set of reasons due to which these circulars have been brought out. So our primary topic today is to discuss about the obligations which have been cast upon certain professionals and other persons by way of these circulars, that is circulars dated 3rd May 2023 and 9th May 2023, which have been brought out under PMLA. So the relevant provisions are contained in Chapter 4, which the heading is Obligations of banking companies, financial institutions, and intermediaries. I would also add to this topic another two words, reporting entities. So obligations of bank, companies, financial institutions, and intermediaries, and there are other reporting entities whose obligations have been discussed in this chapter. And our main concern will be with regard to these reporting entities today. So first of all, before coming straight to the circular or coming straight to the rules, I would like to discuss the law as it exists in chapter 4. So chapter 4 contains the provision something like this. Yes. So first of all, verification of identity. Verification of identity by reporting entity. That is what section 11A contains. It simply provides that the reporting entity, we will discuss about who's reporting entity or not, shall do verification of identity. That is a primary task, first obligation of any reporting entity, that they have to first of all gather the identity proof and authenticate it. So the way law has been drafted, it is not enough that somebody provides a copy of Aadhaar card and that's enough. It needs to be authenticated also making use of the technology in the manner as has been guided, prescribed under the law by way of notifications, sections in the Act, and the rules attached thereto. Then verify the identity of the clients and the beneficial owner both. So word beneficial owner is quite interesting here. So client means the person who is doing transaction with reporting entity. Now beneficial owner means the person on whose behalf the client is interacting with the reporting entity. Immediately the question arises, how would reporting entity come to know about the beneficial owner? Of course, that is a very, very uphill task. But the law is what it is. When the law has made some provisions, it must have thought out the ways and means. Now, the reporting entity will have to demonstrate that as per its understanding made in the normal course of business, the client himself is a beneficial owner, there is nobody else. But if there are primary records or circumstances available indicating that the person who is the client is acting on behalf of somebody else ostensibly, then ostensibly there is some other beneficial owner, and such kind of facts are within the knowledge of the reporting entity, then it is a duty of the reporting entity to cover that beneficial owner also within the framework of these provisions. We'll discuss what are those provisions and what are the exact responsibilities. But as of now, I am saying that it will become the responsibility of the reporting entity. Other thing, section 12. Let us see what does section 12 says. Reporting entity to maintain and furnish records. That is what in just it has been provided under this. Maintain a record of all transactions, whether attempted or executed. Now these two words are quite interesting. Attempted or executed. Now I really could not decipher its meaning. Attempted means what? That the person comes, make discussions, does negotiations, but does not do the transaction. Whether that will be covered here or not, this is a gray area. I mean, it's very difficult to really precisely explain what would be falling under attempted transaction. I mean, attempted will amount only when the advance was given, later on the deal was struck, or at the stage of negotiation itself it is struck. That also will be called as attempted. So, I mean, the law of PMLA has become such that it has become highly stringent and I would say highly infectious, that the moment anything comes which can in any manner touch PMLA provisions, then the transaction should be roped in within the framework of PMLA, whether it is for checking out the offense under money laundering or whether it is for checking out the obligations upon the relevant persons for maintaining us of records and furnishing of records and certain other information. So maintain a record of all the transactions, whether attempted or executed, the nature and value of which may be prescribed. So meaning thereby, within the rules or notifications, some nature and value of the transaction would be prescribed, and that is what the reporting entity has to maintain. Then the second responsibility is furnishing that information to the director. Now, who is director here? Director appointed under PMLA, who is presently designated as director of FIU, Financial Intelligence Unit, whose office is in New Delhi, Jeevandeep Building, Parliament Street. So, furnishing information to the director, of course, the rules will prescribe, other relevant provisions will prescribe where to furnish, how to furnish, in what manner, etc., etc. Then maintain a record of documents evidencing identity of its clients and beneficial owners. So it is fallout of the first section which we read, that since it has to gather identity, so it has to maintain record of identities. Not only authentication is to be done, he has to maintain the record also, evidencing identity, that evidence which on the basis of which the identity has been authenticated. And again, of both client as well as beneficial owners. This is very, very onerous responsibility. I mean, no hesitation in saying so. Then maintain a record of documents evidencing account files. Now, what do we mean account file means? In fact, what the legislature is expecting is to understand the complete financial trail of the transactions as it has happened with the help of the reporting entity. So not merely identity, but the account files also. Then not only that, maintain a record of documents evidencing business correspondence. Again, this with the help of business correspondence, the components of the government or the investigation agencies would be able to gather requisite information to judge whether the transaction entered into and the parties involved therein are genuine, bona fide or not. Because if nothing is clear from account files or simplicity or one or two transactions are done, so the guidance, further guidance will be obtained from the business correspondence which that parties has been making with the reporting entity. The records are to be maintained for a period of 5 years from the date of transaction or date of ending of the business or relationship, whichever is later. So quite smartly, they have said, all right, if you have been continuously doing this transaction, say transaction over 2010, but if you have been doing this business relationship with him even today, then even 2010 transactions record needs to be maintained because 5 years not yet expired. Suppose a business relationship expired in 2015 and no other transaction has been done, then the record needs to be maintained. Say if the business relationship expired in 2015, then it may be required to be maintained up to 2020 only as per law. Why I'm saying as per law? Because as per practice, there are certain transactions where it is better to maintain the record for whole life even. Because what happens to that company or the concerned companies with whom the reporting entities and the professionals may have done transaction, they are roped in into any PMLA or SFI investigation or any CBI investigation, and then the bona fide, the need may arise to prove bona fide of the reporting entity, etc. Then with the help of records only it can be proved. So, I mean, this is a situation which we are facing. Then we have section 12A, which talks about providing information to the director. So it is not only maintaining. Section 12A casts an obligation that the information should be provided to the director. Now, information, he may call for information under section 11A, 12 or 12AA. Then reporting entity has to furnish information as may be prescribed, for which there are rules, which some of which we will study together today. Then 12AA. Enhanced due diligence. Every reporting entity to do following before commencement of each specified transactions. Now we'll understand specified transaction also, but let us understand what are the things which reporting entity has to do before commencement of the each specified transaction. Verification of identity of the clients by authentication under Aadhaar. So, though this has already been provided in the earlier section that identity is to be gathered, but 12AA has been brought out in a manner so as to cast numerous obligations making best use of the technology, and this verification of identity is also one step in that direction. Then second one is more important, and from here onwards it becomes more intense, that is taking additional steps to examine ownership, financial position, including sources of funds of the client. So, I mean, you may wonder that how can a reporting entity, which may consist of professionals also now, can gather all this information? But that is what the law is obliging you to do. And when it obliges you to do, it also simultaneously in a manner empowers you to do that. So if the transactions of such a nature which are prescribed here, then you have all rights to ask the concerned person, the client, that where from the funds are there, what is the financial position. Probably they want to judge, the legislature want you to judge whether the person who is dealing with you seems to be of sound financial position. Suppose he is dealing with a jeweler, he is buying jewelry of rupees 10 crores. So whether that person is of that means that he can buy jewelry of 10 crores. And if not, then he has to find out that what could be the ostensible, what could be the owner behind it or the beneficial owner behind it. And even if there is nothing is known, then at least record of financial position that he does not seem to be man of sound financial position should come on record and should be part of the reporting exercise by the reporting entity. That is what the legislature is expecting. Now, further additional steps to record the purpose behind conducting the specified transaction and the intended nature of the relationship between the transaction parties. So purpose behind conducting the specified transaction and the intended nature of whenever the transaction is not bona fide or there are some suspicions involved therein. Where the client, now this is very, very important thing, where the client fails to fulfill above conditions, the reporting entity to not allow the specific transaction to be carried out. Now kindly see how great power has been given, that that a person may straight away refuse to its client, that taking shelter of the law, that he cannot enter this transaction because the above said conditions have not been fulfilled. What are those above said conditions? That he has not given identity proof, or it is not properly authenticated, he has not explained the financial position, or the nature of transaction seems to be not genuine, etc., etc., or the financial position details are not there. So reporting entity has to increase the monitoring of the business relationship with the client and to make greater scrutiny of the transaction if these are considered suspicious or likely to involve proceeds of crime. Now, how much discretion, how much wide discretion has been given to the reporting entity, that in case they find it suspicious or if it is found likely to involve proceeds of crime, then I mean, he has to increase the monitoring. I mean, this is the task of the investigation agency. So if the task of the investigation agency is being given to the reporting entity, it is, I mean, both the things at a time, it is casting huge obligation, and it is also, I mean, giving, I mean, immense discretion with the reporting entity. Then again, above said information is to be maintained for a period of 5 years from the date of transaction between client and reporting entity. So minimum period of 5 years is there from the transaction, that has to be kept in mind. Now, what do we mean by specific transactions here? We talked about specific transactions. So any withdrawal or deposit in cash exceeding such amount, any transaction in foreign exchange exceeding such amount, or any transaction in high value imports or remittances, or such other transaction or class of transactions in the interest of revenue, or where there is a high risk or money laundering or terrorist financing as may be prescribed. Now, 1, 2, 3 have the tangible parameters. But what about D? In the interest of revenue, reporting entity has to judge. And where the transaction is high risk or money laundering, so reporting entity has to judge whether it is involving money laundering or it is terrorist financing or it is in the interest of revenue to increase the monitoring or to do all this exercise. I mean, this is really something which I am also surprised, but the government must have thought a lot about it, that in what manner these obligations are to be fulfilled about it. And some parameters are already laid down, and I'm sure some other parameters would be also further laid down. Then what do you mean by specified transactions? Suspicious transactions. Now, it is not defined in the Act, but it is defined in the rules with regard to maintenance of records in all these things. So it says it includes transaction whether or not made in cash, which to a person acting in good faith gives rise to a reasonable ground of suspicion that it may involve proceeds of an offense specified in Schedule to the Act, regardless of the value involved, or appears to be made in the circumstances of unusual or unjustified complexity, or appears to have no economic, rational, or bona fide purpose, or give rise to reasonable ground of suspicion that it may involve financing of the activities relating to terrorism. I mean, this definition of suspicious transactions casts definitely, great responsibility upon the this reporting entity. That if he has to also envisage whether there is a reasonable ground of suspicion that it may involve financing of the activities related to terrorism, it is literally going to be very, very strange. But once we inculcate this habit, it may look to be strange, but I'm sure it will rather the professionals and the other persons to do the transaction at arm's length principle. Now, what is transaction here? Again, it is not defined in the Act, nowhere. But when we read rule, we pick up definition of transaction at somewhere. Means a purchase, sale, loan, pledge, gift, transfer, delivery, or arrangement thereof, and includes opening of an account. So opening of account itself has been treated as a transaction. Deposit, withdrawal, exchange or transfer of funds in whatever currency, whether in cash or by check, payment order, or any other instrument, or by electronic or other non-physical methods, means use of a safety deposit box or any other form of such deposit. So suppose I have taken a locker on rent and I have given this locker to my friend for user, then the use of safety deposit again, or I have opened some locker for on behalf of somebody, or I have requested somebody to open a locker, in whatever manner, that will be covered. Entering into any fiduciary relationship. So suppose I become agent of someone on whose behalf I does something, director on the behest of someone, though there are now direct provisions dealing with this after the circular, but it was already embedded within the meaning of the word transaction as per the rules itself. Then any payment made or received in whole or in part of any contractual or other legal obligations. Any payment made in respect of playing games of chance for cash or kind, including such activities associated with casino. Establishing or creating a legal person or legal arrangement. This is quite wide a definition. So forming a company or LLP on behalf of somebody, or entering into any such legal arrangement, whatever legal arrangement, this itself will be a transaction. Then, after the records are maintained, yes, thank you. Then, after the records are maintained, then to make inquiry as it thinks fit to fulfill obligations of the reporting entity. There are powers with the director. Director means director which is appointed under PMLA provisions, and presently director to do this monitoring is director of FIU. It is not necessarily director of Enforcement Directorate. Kindly do not mistake. Given to appoint directors under this act. So power to appoint director can be of any authority of any department. So power of the directors to make inquiries and impose fine. Kindly see both the powers are there. So it can make inquiry as it thinks fit to check whether the obligations are duly fulfilled by the reporting entity. So it can order an audit by an accountant from panel of accountants maintained by the central government. In case of failure by reporting entity, the director may issue warning in writing, direct for compliance, direct for sending report in prescribed manner, impose monetary penalty from rupees 10,000 to rupees 1 lakh for each failure upon the reporting entity or its designated director on the board or an employee. Now, these are very important words, designated director on the board or an employee. Now, these are also been defined under rules that who is designated director and who are designated employees. And we must read it because rope in all directors or any employee who may be not relevant. So we must know. So carefully we should designate who is the director who will be discharging these obligations or some employee. And after designating them, those persons have to ensure that all the obligations are discharged, and everyone else in the company must support them in discharge of the obligations. Then dear friends, this is the law which is contained in a PMLA with regard to the reporting entities, the reporting requirements, etc. And that's it. But hold on, because this is not sufficiently explaining everything, all requisite obligations. And that is where the necessity of rules and reading of the notification comes into picture when section 15 talks about procedure and manner of furnishing information by the reporting entity. It says that the central government may, in consultation with RBI, prescribe the procedure and manner of maintaining and furnishing information by the reporting entity under all these sections which we have read. So I think you will understand now that why there is a need to understand the notifications, circulars, and the rules, that because of section 15, that because of where it says the government may prescribe, government has already prescribed rules, already brought out with the notifications, which are under discussion nowadays. And we will go to peruse them and discuss them. So first of all, you must be wondering, what is reporting entity here? So a few things let us understand, and then we'll go to the rules also. So reporting entity is defined as banking company, financial institution, intermediary. So these are straight away reporting entities. Any banking company, any financial institution, any intermediary. Intermediary means, say, depository participants, stockbrokers, etc., etc., all those persons. It has already been defined. But today is not the topic for the talks. That is why we are not discussing in detail about A, B, and C. Our main topic, our main discussion is to hover around this last item, that is a person carrying on a designated business or profession. So designated business or profession. What is designated business? What is designated profession? That is where we have to discuss the things. Section 2(1)(sa) defines person carrying on designated business or profession. There are 4 or 5 categories. First one is a person carrying on activities for playing games of chance, for cash or kind, and includes such activities associated with casino. They are straight away designated person carrying on designated business or profession. Inspector General of Registration, so meaning thereby registrar of properties, etc. They will also be covered by. They will also be covered by straight away. If you're not doing anything, please listen to the talk. Inspector General of Registration appointed under Section 3 of Registration Act, as may be notified by the central government. Meaning thereby registrars, all registrars are straight away covered. So they are reporting entity. So meaning thereby they have to fulfill the obligation of reporting to the PMLA department. All these transactions which we talk about, specified transactions, and we will also discuss about suspicious transactions, which the reporting of which is required. So kindly see how wide the coverage under PMLA has become now. Then real estate agents, as may be notified by the central government. Now, with regard to this, I could not find any notification. Notion, if you have come to know any notification, or Prabhat or Pranika, any notification with regard to real estate agents, I think it has not come to my knowledge so far. But I think all these property consultants whom we are meeting nowadays, I think very soon they will be covered within the definition of this reporting entity. Then all these jewelers, in whatever manner of metals, precious metals, diamonds, jewelry, silver, blah, blah, blah. Then person engaged in the safekeeping and administration of cash and liquid securities on behalf of other persons, as will be notified by the central. 6th clause is the clause on which we will have elaborate discussion. That is, person carrying on such other activities as central government may by notification so designated from time to time. And that time has come on 3rd May. And before that, the time came on 7th March 2023 also. This notification escaped from the attention of many people in the country. But this is also very important, particularly for those who are already dealing with virtual currencies, Bitcoin, etc., whatever name you may call, or any such currency in any manner. Because the following activities, when carried out for or on behalf of another natural legal person in the course of business as an activity for the purpose of said subclause, namely exchange between virtual digital asset and fiat currencies, exchange between one or more forms of virtual digital currencies, assets, transfer of virtual digital assets, maybe by payment, safekeeping or administration of virtual digital asset or instruments, meaning thereby it covers all those wallets. All these wallets, Binance, etc., all are covered. Participation in the provision of financial services related to issuers, offer and sale of virtual digital asset. So virtual digital assets definition has already been linked with the meaning explained under section 247 of Income Tax Act, where there is a wide definition given with regard to virtual currencies. Now kindly see, what will it become? It will become a person carrying on such activities as may be designated. So what it will become if it comes in the designated activity? It will become designated business or profession. And if it becomes designated business or professions, it becomes a reporting entity. So it has become a reporting entity now. And that's not enough, because we are coming to now the recent circular, which is directly relevant for us. That is circular dated 3rd May 2023, where the government had issued a notification notifying these transactions carried out by the relevant person on behalf of his client in the course of his or her professional, his or her profession, it should be profession, in relation to the following activities. What are these? Now, this is very, very important. So, if a relevant person, now we will understand the relevant person also, who is relevant person, if during the course of his profession, he carries out these activities. So, meaning thereby he is carrying out some profession, and during that course of profession, he does these activities with some relevant person, with some client. So then it will also amount to carrying out of the designated profession. And if it amounts to designated profession, it becomes part of the reporting entity. So the moment these activities are carried out, the person doing these activities will become obligated in the chapter. And note, this is about financial transactions. So we have to understand and chew each and every word. So it should be financial transaction carried out by the relevant person on behalf of his client. So carrying out of the financial transaction and on behalf of the client. These both the things are important. And when we understand both the words, meaning of both the words, then we will be able to decipher the exact meaning of these activities. First is buying and selling of any immovable property. So buying and selling of immovable property for himself, no, that will not be covered. If a professional is carrying out this activity on behalf of his client, meaning thereby if client is issuing him some power of attorney, if client is himself doing, he is advising him, that will not be covered. If he is doing, the person carrying out the profession is doing this activity of buying and selling of an immovable property on his behalf, then only it will be covered. Suppose he is collecting money from the seller, or he is making payment to the buyer, he is signing the document on behalf of the client as power attorney holder, or doing anything which amounts to carrying out of the activity on behalf of his client, then that will be covered. Then managing of the client money, security or other asset. Now this is also again a vague word. Now managing means what? Suppose he is advising his client that what should do his with money. Will that amount to managing client money? No, that will amount to advising the client about managing the money. When he has himself taken up the task from the client that I will manage the money for you. For example, the amount is deposited in an account. That account is under operation or authorized signatures of the concerned professional. He is maintaining some portfolio on behalf of the client, using his professional skill, etc., and discretion involved therein. That will amount to managing of the client's money, securities, or other assets. Then management of bank, saving, or security accounts. Straight away, simple, that if accounts are opened under his control, or if accounts are opened not his name, but in the name of somebody else, but which are in direct management and supervision of that professional, then that will also amount to management of bank, savings, or security accounts. Then organization of contributions for creation, operation, or management of the companies. Let us first of all understand the second part, that is the last clause. Then we'll come back to this. creation, operation, or management of companies, limited liability partnerships, or trusts, or buying and selling of business entities shall be an activity for the purpose of the said subsection. Meaning thereby, what kind of activities will be involved here. If I am advising to a client that how the company should be created, whether that will be covered. Or if I am creating a company myself, that will be covered. It does not talk about advisory capacity role. That if I am advising my client about what kind of company should be incorporated, how should be incorporated. No. If I am myself creating the company, now how would I myself create the company? That I take up the responsibility of appointing directors, shareholders, finding out registered office address, and creates the company and then give it to him. That will amount to creation. Or suppose after creation, I took up the task of operating the company in the manner as may be guided by my client. I appoint my own people or people under my supervision or control, say my directors, my shareholders, etc., etc. Then that will also, will fall under this definition, operation or management of the companies or limited liabilities. So to this extent, it is clear. But the question arises here. Suppose I am advising my client to do the company, formation of a company, and the client says, okay, Mr. Taneja, these are the documents, the way you guided, we have brought before you. You kindly help us draft the agreement. I help them drafting the agreement. They give to me the memorandum and association of and articles of association, certain other documents duly signed by them. They give it to me. I upload it at the site of ROC because I am the professional and I am authorized to do this as company secretary or as chartered accountant. I can create my own login ID and I upload these documents. And after uploading the documents, company is incorporated. I hand over the company to the client. Client does the work thereafter. Will that amount to creation, operation, or management of the companies? Some of the audiences are sitting here with me. Let me ask them also. And if you want to say anything, you can also say, because this is the most burning issue which all of us will be facing today. Yes, Prabhat, what would you say? Advising. Okay, Pranika, what do you say? Have you read the circular? Just read, then say. Don't say on the basis of common sense. Nausheen, what do you say?
No, sir. Do not, because that is a part of the job of a CS, not a CA. That person is doing his own job and he's doing his job, not on behalf of the client. It is his duty to upload those documents.
I think you're right, holistically speaking. The law should be like that. But whether the circular is clear enough to say that, it is saying creation. Now, somebody may say tomorrow, yes, Mr. Taneja, you created the company by uploading the documents on ROC website, etc.
There is no financial transaction involved.
Yes, here comes the need of financial transaction. So that is what I was saying, that each word is very important. Now, there is no financial transaction involved here. But another counter may come, you charge fee for that. So where now the response which I am getting from my colleague sitting here is that they are saying that this is professional fee. But where they are saying the financial transaction other than professional fee, it is not mentioned in the circular. So are they excluding professional fee, financial transaction by way of professional fee? No direct exclusion is there. Therefore, this I consider as a gray area. As on today, though my majority of my understanding says that in such cases, it should not fall within the definition of this designated professional activity. He should not become a reported entity for this reason only, that he guided him. But on the other hand, let us think from the point of view of the legislature also, that they are trying to streamline the economy, monitor the economy very well. So probably they want to take the help of the professionals also, that even if you are guiding with regard to the incorporation, you kindly gather all this requisite information. Because today, tomorrow, maybe after 5 years, we may need some important information for such company. If that company is not behaving well, if they get out of our clutches, who else is there? You are the first person whom we consider as a responsible person with whom we can deal. So therefore, even if we request for the clarification, maybe they may clarify, no, in such cases also it will be covered. This is one way. Other way is Other way of thinking is this, that today also, whenever the investigation happens by the enforcement directorate, now today also, whenever these professionals are invited, then they are asked any question about the company. That, okay, you tell us you had incorporated this company, you tell us about Mr. A, Mr. B, and A Limited, B Limited, whosoever company we are talking about. If, oh, you incorporated A Limited, and these are the directors, these are the shareholders, tell us something about them. And if we do not explain the way we should explain, I mean, the greater problem arises. And so therefore, if today also we are facing this problem itself, then why not to do it in a structured manner and follow the SOPs and then put before the agencies whatever we have done in the normal course of business. Look, what else is expecting other than gathering the information and documents? That's all. So gather that information and documents, provide it time to time, preserve it, again provide it whenever you are asked to do that. That is another way of looking at it. So if you look at it as an empowerment, then it is better to say that even if you are doing the exercise of documentation, it is better to perform the role and discharge the obligation as if you are also one of the reporting entity. At least as far as collection of information is concerned. Then the explanation is also very important. Explanation 1 I had it. For the purpose of this notification, relevant person includes. So relevant person here is including these categories which are mentioned. It's not defining it. So relevant person is not defined exhaustively. Relevant person's definition is inclusive definition, meaning that it says that these will be included. Others may be there, whosoever is carrying out these activities. So anybody who is carrying out these activities, 1, 2, 3, 4, 5 before you, they will all be considered as relevant person, but these will definitely be considered. Why they needed a specific need? Because any of these persons may say, sir, I have done it in a professional capacity. So maybe to rebut that, to clarify that, to preempt that, they have brought out, aap to include honge, all these 3 persons will be included. And that is why I am saying even if it is done in professional, during the course of profession, so they wanted to include it. Even this documentation uploading part. Though next circular is also important where they have excluded something, but whether they have excluded the documentation uploading part or not, that is what we need to understand. So that takes me to the next circular. That which was issued on 9th May 2022, 9th May 2023, in pursuance to that only, that what should be designated business or profession. Now they say again the same thing. Activities carried out by a person on behalf of client. यहाँ financial transaction की बात नहीं है, दोबारा check करो. In 9th May, it does not talk about financial transaction. It says following activities when carried out in the course of business on behalf of or for another person, as the case may be, as activity for the purpose of the said subclause. Right? Acting as a formation agent of the companies and limited liability partnerships. Now, though there is no formally accepted or prescribed or allowed concept of a formation agent of companies here in India. In India, law does not allow anybody else to act as agent for formation of companies. In countries like probably in Singapore, some other countries, such kind of concept may be prevalent, not here. But somebody may say this taking up of documents, uploading of the document is also like acting as a formation agent. So, I mean, because of want of clarity, these kind of arguments may come up. So for this reason also, I would say that there also you presume yourself to be a reporting entity, to be on the safer side. Yes, you may suggest that, Mr. Taneja, we should file some writ or take up this matter before the government in any other manner and seek clarification in this regard. Otherwise, it will cast onerous responsibility upon many people. That I agree with you. Then second activity here is that acting as or arranging for another person to act as. Both the words are important. Director or a secretary of a company, a partner of a firm, or similar position in relation to other companies. So suppose a holding company is arranging for something in subsidiary company. So director or secretary of a company. So if I myself choose to become a director, whether I am a professional, not a professional, anybody, because it is, this circular is for anybody and everybody. Become a director, or I introduce somebody, somebody known to me from my village, somebody, my driver, somebody, my peon, etc., etc. I appoint him as director of the company. They say, then this is an activity of a reporting entity. Then what he has to do? He has to act as a reporting entity, and he has to gather the information of his client, meaning thereby of the company of his becoming. So all this exercise is just becoming the director. He has to gather all this information. Then providing a registered office, business address or accommodation, correspondence or administrative address for a company. So in any manner, if any address is provided, that activity itself will place that person in the category of a reporting entity. But if it is for in lieu of rent, it has been specifically excluded by way of an explanation. So if you enter into a lease deed, then there is no problem. So this I could not understand. So somebody who does not want to be reporting entity but wants to provide the address, it is better for him to then enter into a lease deed of with rental, receive the rental, and then he will not be a reporting entity. Then acting as or arranging for another person to act as trustee of an express trust or performing the equivalent function of for another type of trust. So now becoming trustee, which was very trustworthy job, has become this onerous to this extent now. Then acting as or arranging for another person to act as nominee shareholder for another person. Sometimes you become nominee shareholder because there are in wholly owned subsidiary also, there has to be one nominee shareholder. There could be 99% shares of the holding company, not 100%. So holding company holds 99% shares and 1% share may be held by the nominee shareholder. So they say, even if you become nominee shareholder, you become immediately a reporting entity. Then it is necessary to read some exceptions which are given with this slide only. I mean, in this notification only. Any activity that is carried out as part of any agreement lease, this I already read, that if you become a tenant, landlord-tenant relationship is excluded. Then any activity that is carried out by an employee. So if any employee becomes the director, no problem. Then he will not become reporting entity. Suppose there is a very big group, big business empire, and it nominates a person as its director in various of its subsidiary companies. If that person is not employee in any one of the companies, then that person will become reporting entity. So he has to be first an employee. Then if he discharges these obligations which are mentioned above, then it will not fall within the definition of reporting entity. Then what is also excluded is any activity that is carried out by an advocate, a chartered accountant, cost accountant, company secretary in practice, who is engaged in the formation of a company to the extent of filing a declaration as required. So suppose a client comes to me and he seeks my help for formation of company, and I only sign that subscriber sheet. Then it says, no, that will not be reporting entity. That will not fall within the definition of the designated activity. But that question remains here, and rather it reinforced that this thing has been specifically excluded, this signing the subscriber sheet, but whether filing of documents, why not that has been specifically excluded? It is an omission, or it is a conscious act of the legislature. So that question coming up again here. So I would advise any suggestions or ideas on that. So somebody may say, look, even signing of subscriber sheet has been excluded, so filing of the document is nothing. So that should also be excluded simultaneously. Another thought may be, no, only signing specifically whatever legislature does, we have to give and make an understanding on the basis of that only. We should not imply anything. So if this thing has been specifically excluded, they could have excluded that also. They have not excluded that, so that will not be excluded. That means that filing of the documents, drafting of documents and its filing. Then this intermediary thing that has already been covered in intermediary, therefore that has also been excluded here. Now, who is client here? Definition given under section 2(1)(ha) defines client as person who is engaged in a financial transaction or activity with reporting entity, and included a person on whose behalf the person who engaged in the transaction or activity is acting. So suppose Mr. X come to become a client, he does some financial transaction, with me, he will be covered. But if it is known that he is doing it on behalf of Y is the person controlling, that Y will also be client. But this financial transaction thing is the part of the definition. But in this section, that is the circular 9th May 2023, this word financial transaction is not there. And it talks about person on behalf of such client. But client has to be somebody on behalf of whom financial transaction is done. Then financial transaction is not done here. Then how come these things, that is providing a registered office free of cost or becoming a director, will also be covered here? So thought on this is that somebody said to me yesterday that if he becomes a director, under his supervision, many transactions will happen. Those will be financial transaction. But that will not be financial transaction between director and the company. So if he is becoming director on behalf of the company and he is not doing any financial transaction with the company, director and company are not doing any transaction. So how that requirement shall be fulfilled of doing financial transaction? So, and to be a client, there has to be a financial transaction. So to this extent, some dichotomy is left, and probably they will be also plugging it up very soon. Now, who is a beneficial owner? Again, the definition has been given. Beneficial owner as an individual who ultimately owns or controls a client of a reporting entity, or the person on whose behalf a transaction is being conducted. Transaction is being conducted and includes a person who exercises ultimate effective control. Who exercises ultimate effective control over a judicial person. So beneficial owner definition is quite clear, and that is what we discussed and understood in the beginning. Then rules. So in support of all these obligations, how KYC is to be done, how records have to be maintained, how information has to be furnished, etc., etc. For this and for what kind of transactions this is to be done, rules have been provided because of the power given under section 15. इसकी slide को ना इससे पहले करते हैं section 15 की slide. So every reporting entity shall maintain the record of all transactions, including the record of all transactions of the value of more than 10 lakh rupees or its equivalent in foreign currency. So sometimes transactions are divided into parts, but integrally they are integrated. Then they say if you find transactions integrated, then kindly add them up, and if they happen to be more than 10 lakh, you cover them up here. Then all transactions involving receipts by non-profit organizations, again more than 10 lakhs, or its equivalent in foreign currency. Then furnish information. Then information in respect of transaction referred to in clauses A, B, BA, C, and E of sub-rule 1 of rule 3 every month by 15th of succeeding month. This is the obligation that succeeding month 15th should not be crossed without furnishing of this information to the director. Then in case there is any suspicious transaction, very, very important, any suspicious transaction, then they say you kindly do it within 7 days. This is such an it's onerous responsibility and empowerment also, if it is felt like taken it up like that. Then any transaction in respect of a transaction, any information in respect of a transaction referred to in clause F of sub-rule 1 of rule 3 every quarter to the director by 15th day of month succeeding. Then for the purpose of this rule, delay of each day in rote reporting a transaction or delay of each day in rectifying a misreported transaction. This is very, very smartly worded rule that in case delay happens, then it will be constitute a violation. And it will be separate violation for each transaction. And penalties are huge, rupees 10,000 to rupees 1 lakh for one transaction. So if you have under 100 transactions, even if the cost is minimum of 10,000 multiplied by 100, and there will be 100,000s of transactions. Then due diligence. Then with regard to due diligence also, again the rule has been provided that in what manner diligence is to be done by identification, etc. Identifying the beneficial owner, taking all steps. Now in other cases, other than the cases which we have discussed, verify identity while carrying out the transaction of an amount equivalent to or exceeding rupees 50,000, whether a single transaction or several transactions which appears to be connected. So if it is not falling in the above category, then rupees 50,000, even if it is transaction of rupees 50,000, it will be covered here. Then every reporting entity within 10 days after the commencement of the account-based relationship with the client, file the electronic copy of the client's KYC records. So if it is an account-based transaction, the law envisages that KYC records should be updated time to time, should be filed. Then some of the, because time is up, so some of the rules, which are plain simple rules, which you can study with regard to the compliance, you can please study them. And it clarifies what is to be done exactly, how it is to be done exactly. Then furnishing of report to the director, then how the report is to be furnished, whenever it is required, in what manner the report is to be. So these are with regard to the provisions of the Act and the rules. The rules have to be read in extenso. Now I have made few slides also for your benefit, which are showing that there are various countries which have already implemented these rules, these provisions. For example, Canada, there are over 24,000 Canadian financial institutions and designated non-financial businesses and professions like we have now brought out. So these 24,000 entities are covered within the PMLA network, reporting entity. Then Europe also, then USA also. Then they have made out anti-money laundering rules also. Then United States also. This I've already covered. So these are the recommendations of FTA. You can read them. These are just to show the specific thing. So that's it from my side as far as basic provisions are concerned. Now you can open the session for 5-10 minutes. If there would be certain questions, issues of some of the professional colleagues, I would definitely love to give my views and thoughts on this. So if you can please open the chat box or the unmute the participants if anybody wants to ask any particular question or something like that. Yes. Friends, anybody, whether organizer will be making it unmuting them or it is not possible to unmute, then you can type the question. Sumita ji, are you there?
Hello.
Yes,
Sir,
yes.
we don't see any questions put up so far.
Okay.
So, yeah.
Any if you want to unmute, if anybody wants to ask any question. Yes, somebody is asking a question. Yes, this PPT, the PPT you will be sending to everybody. I'll be just sending.
Yes, sir, definitely. We shall be sending the PPT along with the link to watch the recorded session.
Okay.
No,
So
sure.
I have already forwarded you the PPTs.
Yeah, we will be doing the necessary thing and then we will be sharing it by tomorrow positively.
Okay. And the next question here is, for creation of company by CSCA, will there be any PMLA attracting? Now, this thing I wanted to say in the beginning. PMLA law is not being attracted upon you. PMLA law can be divided broadly into two parts. The persons who are guilty of offense of money laundering, how they have to be punished or how their properties are to be attached, or any other property who possesses proceeds of crime or uses them or integrates them or layers them. That is one part. Other part is obligations upon certain persons to make reporting of certain provisions. So these circulars or these rules which we have discussed has nothing to do with the first part. Nobody, even if he does not report, can be held guilty of offense of money laundering in any manner. No, this is not being decided who is guilty of offense of money laundering or not. This is just to help the people, concerned persons, relevant persons to discharge their obligations of collection of identity, information, maintenance of records, and furnishing of records, time to time as may be prescribed. So even if you have not done this, or anybody concerned person has not done this, he will not be held of guilty of offense of money laundering. No, he will at the most be directed, warned, given opportunity to rectify, provide information, or ultimately fined. That's it. Nothing to do with offense of money laundering. Be rest assured on that. So that is why I am saying it's a measure of empowerment also. Yes, any other question? How a
Yes.
practicing professional?
Yes, sir.
Yes.
We have received some questions in Q&A section also.
In which section?
Q&A.
Q&A. Okay. Okay. How a practicing professional can do KYC of a client? Very good question. In fact, it is also provided here that in case a client is not helping, then kindly do not do the transaction with him. And now it is not only you will be doing, everybody else has to refuse it. So client has to cooperate. Now in cooperation, KYC is the minimum thing which he will give. Unless he will give KYC, how the things will proceed? As far as the technological compliance is concerned, I think in course of time we'll understand. Let further guidelines be there. There may be some hassles. I will request respective institutes to help the professional in that direction, impart requisite training, which institute is already doing. So I think that is not going to be the major problem here in as far as this area is concerned. Sandeep Singhji is asking, can a company incorporate for on behalf of law firms? How would this be viewed? Look, I have read two circulars. First of all, in first circular also, they have said relevant person includes this. Meaning that does not mean nobody else will be included. Others will also be included. So whosoever does those activities as are prescribed in circular 1 or circular 2, that is 3rd May or 9th May, they will be covered. If they are to be covered, even for the documentation part. But if other activities which are straight away covered, they will be covered. Because it is for anybody and everybody. Mukesh Kumarji is saying, will a CA assisting Indian clients to have open foreign subsidiaries in Singapore, etc., be covered under the regulations? That is what I said precisely. That if everything is being done in the name of the company, it should not be covered. So signing of subscription sheet should not be covered. But filing of documents, one thing. Another thing which I forgot to mention and discuss with you, sometimes we receive fee from client for onward deposit with the government departments, like fee or taxes, like ROC fee or income tax, GST or any other such government levies or taxes. Will that amount to carrying out of a financial transaction? According to my holistic understanding, it should not. But it is a gray area. It is better that we all do transaction at arm's length. We compute them the fee, give them the chart, tell them where is to be deposited directly, stay away from that. So at least you do not fall within the category of doing a financial transaction. And with regard to this company, Singapore company, also my answer remains same. Mukesh Kumarji is asking, further the law be different, will the law be different between a CA holding COP and not having COP? When I am saying it is all inclusive definition, institute may take action against a person not holding COP still doing this exercise. But this PMLA has got nothing to do with it. Each and everybody will be covered. What KTC should a CS ask? KTC means what? What KTC should a CS ask? Probably KYC you wanted to say. Any declaration before incorporating company. KYC as has been prescribed. You have to follow the SOPs and guidelines. Rule 9, just go to rule 9 and follow it. So I think that's it.